think we're headed in the right direction. We'll see, though. Welcome, everybody. All right, we are finally at the bias section, so that's pretty exciting for yours truly. Yeah, it's kind of what I've been waiting for some months. Yikes. I'll take that as not being part of the script there, but we're getting there. Every day at a time. All right, so if you do not recall, we had a couple days break there. I've got a few great stories to tell you about that. Mostly what happened, to start out with, is somehow, despite being given the chance not to drag me down to Madison at, which is, 90 minutes away at 8 o'clock in the morning, the Department of Corrections dragged me down to Madison at 8 o'clock in the morning. Which meant that I had to leave at like 6. So that was something. Let's say there's some great footage that came out of that one. But mostly, as far as I understand, that once again, they tried to keep Secretary Carr, Amy Petchacek. I hear it's Pahasek, by the way, but I'm from Milwaukee, as I always say, and however you want to pronounce your name, that's fine with me. It could change from day to day, street to street. Hey, we've got a name, Miller. Sometimes people spell it M-E-U-L-L-E-R. Sometimes they spell it M-I-L-L-E-R. And a few other ways. There's got to be 12 different pronunciations, if that, if not more, just for starters. So we have this unique phenomenon here about sort of German last names, for example, and how they're actually pronounced in Germany, how we think they might be pronounced, how a romantic pronunciation, an Americanized pronunciation, an anglicized pronunciation, and so forth, just for starters. And then how things change. Just on that subject, on the subject of language changing and so forth, Village of St. Cloud, as you know, there's the Holy Land here. I have had several people tell me that German for cheers is Ein Prosit. And just couldn't believe it. This is with a B, not a P, for example. And as in ptarmigan, B as in Brussels sprouts, for example. So it just shocked me. And I commented on it because I thought it was kind of amusing. And many people, I think, rightly responded that language evolves. So that's me going back on your chomping on the bit, however you say it. The first rule of communication, just like the rule of the road, is communicating and being safe. The second rule is, then we get on to art. So if you don't understand what I'm saying, do not hesitate to let me know. If you have, you don't like my means of vocal production, I'm more than open to criticism on that. If you feel like my use of the English language could use some work, by all means, let me know. But just understand that's my order, my hierarchy here is communication and then art. All right. So I hope we are ready to go. Are you? Let's do it. Why, hello there. All right. So we are on this section up here, alleged a secret conflict. Okay. So we'll see what they have to say. The complainant's brief refers to a secret conflict never disclosed to the complainant. The complainant's argument on this issue is not always easy to follow, but it has, but at its heart are two facts and then many unsupported and nonsensical claims. Well, that's nice. The two facts, I might dispute that. I think there's probably more than two facts, but we'll see. The two facts that are Amy Petchacek was the DOC Deputy Secretary when the events surrounding the complainant's claim occurred in 2020. I think I'm going to have to go with that guy. She just happened to be, she was like sitting there minding her own business, and then these events surrounding the complainant's claim occurred. I mean, that's, wow. That's like what had happened was, or to put it another way, I was just sitting here minding my own business, and that vase fell down and knocked itself over. If you know what, if you follow me. And Amy Petchacek, or Pahasek, is currently the secretary designee of DWD. So I'm going to add a few more facts there. Fact one is that the complainant did not know about the fact that these two people were the same person until after the hearing. That's a fact. Unless you've got some, so you have evidence to counter that, I'd like to hear it. But according to the fact that I put in there, that's the case, because it is. So then we also have to look at, these are unsound, okay, so those are the only two facts. Everything else, by the way, then, according to her, is going to be unsupported and nonsensical. Another fact that we have is that Chrissy Preston reported to Amy Pahacek. It's another fact we have. We have another fact that Carr testified that he discussed it with Amy Pahacek. We've got another fact that Novak sent an email to Carr saying that him and Pahacek were conflicted because they had already made a determination. So those are facts that I put into my motion on this issue here. So that's the key thing here, is where she gets this concept, and we'll go forward, that somehow we knew about this conflict beforehand. That's something. And then we'll see what happens. All right. I'm getting ahead of myself. One argument that the complainant makes about this is that the administrative law judge or the division should have informed the complainant about the conflict that arose because Pahacek was the DOC secretary when the event surrounding the complainant's claim occurred in 2020, and because Pahacek is currently the secretary designee of the Department of Workforce Development. Why, hello there. All right, so we are going to go to SCR 2017. SCR, what does that stand for? Supreme Court rules. I can't possibly pass up the opportunity to remind everyone of the Satirical Onion's headline here. What I think about says it all. They used to have these little blurb headlines on the side there. And the caption there was, Supreme Court rules, Supreme Court rules. I think that says it all. In fact, I take that back. There was an entire several paragraphs about, it's really funny, all of the different, and this is like 98, 99, somewhere around then, all of the contemporary Supreme Court justices explaining to you why they're rock and roll. Pretty amusing. All right. So conflicts of interest, current clients. Okay. So that seems to not be applicable when we look at it. By the way, the Supreme Court rules 20. There's other Supreme Court rules about how you record in a courtroom or what. There's all sorts of Supreme Court rules. Some of them are on ethics. These are the ones that we care about here. So as you may recall, administrative law judges or hearing examiners are not judges. They are merely called judges by courtesy. In fact, they're just attorneys who work for the governor. So they are not bound by the judicial code of conduct. However, they are bound by the Supreme Court rules for attorneys. So let's look here. Conflicts of interest, current clients. Okay, except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent client conflict of interest. A concurrent conflict of interest exists if, one, the representation of the client will be directly adverse to another client. Does that apply here? No. Because her representation of the Department of Workforce Development is not directly adverse to the representation of the Department of Corrections, because she does not also represent the Department of Corrections. Okay, so we can move on from that one. Okay, that's absolutely, there may be appearance of bias, there may be all sorts of other things going on, but we're just talking about a straight up conflict. Okay, those are two separate matters, by the way. Bias occurs when there's a reasonable apprehension that there is, what we say bias, but that is prejudice, meaning the judge, by some operation, by some relationship, is assumed to have prejudged the determination that they're supposed to make. Because remember, what does a judge do? They judge, and if they prejudge, that's a violation of due process. Okay? Prejudice, prejudge. Got it. So the reason that we're talking about that there is that's not the same thing as a conflict of interest. Okay? Those are two bias. A conflict of interest can lead to bias, but for example, there's other kinds of bias. Remember, let's say you're going up against a case and the person on the other side happens to be the daughter of the judge. Conflict of interest. We don't have to guess at whether or not there's really a conflict. Just the appearance of that is not good. We ordinarily assume that those familial bonds are probably going to be stronger, or if not stronger, influence in an improper way. So we don't accept that. If there's a financial relationship, we don't accept that. Sometimes if somebody has criticized a judge, for example, we don't allow that judge to judge that case. So for example, let's say I ran against a judge for an election, and then I was charged with disorderly conduct. It would very likely be improper for that judge who I ran against to hear the case against me. And I certainly would move to have them recuse themselves on that grounds. Hypothetically, of course. All right. Now we're getting into two. There's a significant risk that see, we're back. Remember that parallel language, significant risk of actual bias. This is significant risk of a conflict. And again, the significant risk part doesn't mean you don't need to actually have proof, but you got to have more than just an allegation, okay? Best one I can think of is there's an ERD case that says a judge and the attorney go to the same country club. That's not enough. Judge and the other attorney are at a country club and they're seen talking about the case, bam. But it's not enough just that they're merely, even they sit next to each other. It's not enough. Okay, significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by the personal interests of the lawyer. So let's just look at the last one there. We'll go through one or more clients, so that's out. Another client, a former client, that's out. There's no allegation that she represents Amy Pahasek. A third person, well, that would qualify. Now, again, just the fact that there's a third person, it has to go back to the beginning there, a significant risk that the representation of one or more clients will be materially limited by a third person or a personal interest. One personal interest, for example, could be having your paycheck signed. We know that is parallel to bias, too. If you're getting you have a contract, a business relationship with that person, that's impermissible and as the appearance of bias. That, as far as I understand it, it's those section there, a former client or a third person, or by a personal interest of the lawyer. It's that third person and personal interest of the lawyer. Okay? Now, what does that trigger? If there is a conflict of interest, it has to be disclosed. That's the key thing here. Because notwithstanding the existence of a concurrent conflict, the lawyer, you can still represent them, but you've got to be doing a bunch of these things. One of which is informed consent, that's of the client, but then it goes down to duties to third parties and candor, and that's where that kicks in. You've got to tell them, other parties, that there's a conflict. So I'll save you the rest of that, but we'll switch back here to this decision. Bam. All right. One argument that the complainant makes is that the administrative law judge should have informed the complainant about the conflict that arose because Pahasek was the deputy secretary when the events were on. Okay. Now, the reason I make that argument is because it's required by law. And the reason it's required by law is because she's got the duty of candor to other parties, and she's got to tell us, hey, there's this conflict. She abrogates that entirely. We'll see. All right. Aside from whether there is any conflict that arose from the two positions held by Petchacek, hopefully we'll get onto that. The complainant's claim that the administrative law judge should have told the complainant about this does not make sense. Okay. And this is true. This is a kind of logic, I think, that we're going to call bureaucratic logic, and meaning it's your actions excuse my inaction. My failure to follow the rules is because of you did something. Okay. The ERD administrative law judges have large caseloads. And the administrative law judges do not scour each case file to find potential issues that the parties may have missed. The administrative law judges may raise an issue if the administrative law judge notices it. But generally, the administrative law judge expects the parties to raise issues for the administrative law judge to decide. Did you hear anywhere in there that she didn't know that Pahasek was her boss or a bad actor in this case? I didn't hear that yet. We'll see. Maybe there's more. While the complainant states that the administrative law judge should have told the complainant about the conflict, the complainant does not state how and when the administrative law judge would have known about the alleged conflict before the complainant knew of the alleged conflict. Sure. You know, maybe when you read your paycheck, just for example, maybe, and this is right in there, when you look at the decision, or how about the hearing notice when Amy Pahasek's name is on the hearing notice? How about there? Okay. But again, the fact that I know about the conflict does not relieve her from her responsibilities under the Supreme Court rules. Now, I did know about the conflict, but let's say that I did. She still has the conflict, and she still has the duty to disclose the conflict. You have to disclose a conflict, even if you think the other person knows about it. But apparently that rule doesn't apply here. The complainant, did not file a motion with the administrative law judge claiming that there was a conflict due to the positions that Pesacek held at the DOC and DWD prior to the hearing. That's 100% true. Tell me how that changes the Supreme Court rules, will you, please? The complainant did not list Petchacek as a witness in the case. The complainant did not file a motion with the administrative law judge claiming there was a conflict due to the positions of Pahasek and the DOC and the DWD prior to the hearing, right? Did it afterwards. You got it. The administrative law judge only became aware that Pahasek was the DOC deputy secretary when the complainant's attorney introduced Respondent's Exhibit 27 as an exhibit during DOC Secretary Carr's testimony. There you have it. At that point, the document only showed that an email sent by Carr to the complainant to support the complainant's position was emailed to Pahasek without comment. Well, no. No and no, and that Pahasek forwarded the email without comment to Christine Preston, the Director of Internal Affairs. So the complainant's email could be considered in the Internal Affairs investigation. Our hero. I encourage all of you, we'll have to cut this here because we're at the 20-minute mark. We'll talk more later. I encourage all of you to go back and watch those Carr recordings. Anybody who can give me a file stamp, I would appreciate it. You know what I mean? Like, hey, this is where, because you can see her face, as I recall, um, reacting quite visibly, and that wouldn't be a bad short to make. So if we had some timestamps, that would be very helpful for that. Um, all right, so we got the music. For some reason, it's all digitally geeking out. Hey, we're getting there, one step at a time, as they say. So, I hope this was as exciting for you as it was for me. We're going to keep going, but how can I say that? There is, in this, let's say, I can make a simile. Just as in the preceding section, where she said that we didn't need the law and that not having access to those cases was immaterial, and then she proceeds to cite the cases. In the same vein, she says that it was everybody's fault but hers, but then now admits that she knew about um, the fact that her boss was an actor in this case on the first day of the hearing. And of course, it's my position that she should personally be responsible for all of the wasted time in the hearing because she didn't divulge that conflict of interest to begin with. What do you think? Let me know. Stick with us, by the way. We shall keep you informed. Take care.